Welcome to the Weekend Brief with Bharat.Law for the week starting May 4th, 2026. This week, we are covering a diverse array of civil, criminal, and administrative disputes. We begin with corporate and commercial law. In a major relief for home buyers, the court ruled in the Alpha Core case that the corporate veil can be lifted in real estate insolvencies. If a holding company uses subsidiary companies merely to hold leased land, the entire project can undergo resolution together to protect buyers. In another insolvency case, Dhanlakshmi Bank, the court firmly stated that the Insolvency and Bankruptcy Code is not a debt recovery tool. If a bank's loan disbursement is tied to a third-party builder's performance, the dispute is contractual and the bank cannot initiate corporate insolvency just to recover its money. Moving to arbitration, the Elecon engineering case expanded the scope of who can invoke an arbitration clause. The court held that a non-signatory collaborator, who is a veritable party to a contract through joint undertakings, has the full right to invoke arbitration. And in company disputes, the Dr. Best Surgical Institute judgment ruled that an investor can be legally considered a member of a company to file for oppression and mismanagement, even if the company wrongfully failed to enter their name in the official register. Next, we look at contracts, property, and civil rights. The court delivered two important rulings on the specific performance of property contracts. In Habban Shah, the court ruled that if a buyer fails to deposit the balance money within a strict court deadline, the contract is automatically cancelled. However, in Anand Narayan Shukla, the court clarified that judges have the equitable power to extend this time limit if the delay was not the buyer's fault, ensuring justice over strict technicalities. On property titles, the Vdyala Prabhakar Rao case affirmed that revenue records like Pahani's only show tax liability and possession. They cannot prove actual ownership of land without original title deeds. In Sitamma versus the state of Karnataka, the court ruled on the protection of SCST lands. It held that family members who willingly participated in the illegal sale of protected land cannot later use the law to cancel that very same sale. Meanwhile, the Manjula case dealt a heavy blow to Benami transactions. The court ruled that the 2016 amendment to the Benami Act applies retrospectively. Properties held in another person's name to bypass land reform laws are liable for immediate confiscation. Shifting to consumer rights and tort law, a critical judgment for medical negligence came in Kumud Lall. The court ruled that while personal injury claims against a deceased doctor die with them, claims for quantifiable financial loss survive and can be recovered from the doctor's legal heirs and estate. On motor accidents, the Hansraj judgment set a humane precedent for minors suffering 100% permanent disability. The court enhanced the compensation to over 56 lakh rupees, mandating that notional income must be based on minimum wages, and ordered structured fixed deposits to ensure lifelong attendant care. Now, let us discuss criminal law and police discipline. In Sujal Vishwas Attawar, the court addressed the growing trend of misusing High Court writ jurisdiction to register FIRs. It ruled that citizens must first exhaust statutory remedies under the new Bharatiya Nagrik Suraksha Sanhita or BNSS before approaching the High Court. In the murder case of Sanjay Singh, the court clarified the concept of common intention. It held that merely being present at a crime scene with a firearm without proof of a pre-arranged plan is not enough for a murder conviction and altered the appellant's charge to attempted murder. In disciplinary matters, the state of Jharkhand versus Ranjan Kumar case upheld the dismissal of a police constable. The court found he had used a forged identity to simultaneously secure a job in the Bihar police, stating that fraud at the entry level of public service justifies immediate dismissal. Similarly, in the Nigam Prakash Narayan case, the court reduced a harsh penalty against a 76-year-old doctor. It ruled that the medical commission cannot punish a professional for a charge that was never originally mentioned in their show cause notice, as this violates natural justice. Turning to public recruitment and service rules, the RPSC case brought strict clarity on eligibility dates. The court ruled that candidates must possess their required educational degrees on the exact date of submitting their application, not later during the exam or interview stages. For contractual teachers, the Sunil Kumar Yadav judgment delivered a balanced directive. While the court refused blanket regularization for para-teachers in Jharkhand, it directed the state government to strictly implement its own 50% reservation quota for them through annual time-bound recruitment. In a separate recruitment case involving the Durgapur steel plant, the court held that just because authorities lose or destroy exam records, it does not automatically mean a candidate passed the exam and deserves the job. And in the state of Tamil Nadu versus Cypria, the court ruled that seniority disputes over promotions become purely academic and moot once both parties have already been promoted to higher administrative posts. Finally, in environmental and infrastructure news, in NITU solvents, the court offered relief to operating manufacturing units that lacked prior environmental clearance due to initial errors by the pollution control boards. The court allowed them to operate while seeking ex post facto clearance, prioritizing the protection of local employment. In the power sector, the Indian Railways lost its bid to be treated as a deemed distribution licensee under the Electricity Act. The court ruled that since the railways uses power for its own internal operations and does not supply electricity to the public, it is simply a consumer and must pay cross-subsidy surcharges. Lastly, in DERC versus Tata Power, the court ruled that a power company cannot charge Delhi consumers for the depreciation costs of a power plant for the period after the plant has stopped supplying electricity to them. Log on to Bharat.Law for updated research, document intelligence, court notifications, and elevate your legal practice with trusted AI. Until next week, this is Nyay, your trusted AI on Bharat.Law.